This afternoon, you're listening to the Todd the Borowitz Show, Real Estate Radio and Salem Broadcast Network, WRC 1260 AM. I'm your host, Todd the Borowitz, and this segment is brought to you by Jim Musgrave at Research Financial Strategies, our preferred partner for financial planning. And with us in the studio is Ted Stein. He's the principal attorney for law offices of Theodore P. Stein, PC. Now, Ted, how you doing?
I'm doing well. How are you, Todd?
Good. Well, I'm going to have to connect this for our listeners because we are a real estate radio show. And what's the worst thing that could happen to you if you lose your job? And you stop paying your mortgage or you have to dip into your reserves. And we're kind of taking a step back and we're going to educate our listeners about the employees' benefits and what your rights are and what the employer's rights are so we can protect everyone's stream of income. So you wanted to mention something about the importance of an employee handbook.
That's right, Todd. An employer should have policies written down so that, first of all, it's clear to the employees what those policies are, and it's important to follow the policies if you're going to have a written policy. But
do people really read the handbook? Or do they just PDF it to you and say, here's your email, sign off saying that you received it?
Sometimes they do and sometimes they don't. I think they normally do. And the employee handbook should have a receipt or an acknowledgement that each new employee signs to show that he or she actually received it. Because sometimes the policies can be disseminated or the employer thinks that they have a policy that's clear, but the employee can say, I never got it. So it's important to start there. Plus, there are some benefits and some rights that the employer would have to defend against, for instance, a sexual harassment suit if there are certain policies, certain complaint procedures in place that are in writing that enable the employee who has a complaint to go to an HR person or to a senior executive or an officer and make a complaint that would potentially insulate the employer if it's a coworker who may be guilty of harassment of another worker.
Wow. And what about cell phones? Because I know what I heard is, let's say I have an employee phone, and I'm in the car, and I'm texting and driving as you're not supposed to, and get into a car accident. The person that gets hurt can sue the person driving the car, their insurance company, but if they can get a copy of their phone records and show that they were actually texting or reading an email or calling someone while they got into that accident, it could spill over into the company that gave them the phone. Is that true?
Sure. I mean, anyone can be involved in litigation, particularly personal injury litigation. So what we counsel our employer clients is to have specific provisions in the employee manual that says you agree you don't text, you're not on the cell phone when you're driving. If it's an employer issue, you have no reasonable expectation of privacy. If it's our equipment, we can monitor it. We can pull recordings. We can do what we need to make sure you're in compliance with our policies. Now, does that necessarily keep you out of a lawsuit? No, but it may give you the ability to get dismissed at an early stage.
Talk about Big Brother. And what about the problems of privacy with the people that are getting computers, laptops, they're getting cell phones to take home? Like, I know for me, like, I gave a computer out, and it's like I never got it back. I had to fight for it. But what can employers do?
Well, if it's an employer equipment, first of all, there should be something in the handbook or in other written policies that say you have to give it back when you leave. And the other thing is you can only use it for company policies and for company business. And therefore, you have no expectation of privacy on devices. Could be a tablet, could be a cell phone, could be a laptop that are issued by us and are owned by the company. You have no expectation of privacy, so don't expect one. And the employer should monitor from time to time, and most employers do. But you need to give that warning and that notification to the employee so everyone's on the same page.
So you basically can say, look, it's in our policy that we're going to be Big Brother watching you. It's not a little creepy?
Well, it's not an unreasonable expectation. I think the carve-out is that the employer would say in the handbook, we understand there may be an occasion when you need to use a company phone to make a call, to call home to see if things are okay. And we're not talking about that. But by and large, we don't want you to be using company devices for personal items.
What are some things you're seeing that the message is really for.
Well, we see, certainly employees are using social media to a degree never before seen, as Facebook and Twitter and other accounts have become so big in our society. And so, for example, there needs to be a clear-cut policy that you're not representing the company when you're on the internet. And therefore, you have to make it clear that you're not speaking for us when you're in a personal chat room or on
Give me
Facebook.
a story that can kind of explain it, of a situation that you've been through.
Well, a story that I've heard, I don't know, this isn't necessarily my experience, but is that, you could weigh in on a political issue and take a position that the company doesn't take. I mean, there may not be any position for that. But because you identify yourself as an employee of company XYZ, people start calling the company and saying, we understand you've taken a position on this important issue. And it can be a controversial issue. So the employees need to be alerted that they're not speaking for the company, and there needs to be something in writing to that effect.
Okay. Well, by the way, if you're just tuning in, I have with me Ted Stein, attorney principal for law offices of Theodore P. Stein, PC. I'm your host, Todd Laborwood, and you're listening to Salem Broadcast Network, WRC 1260 AM. Now, one thing that we talked about is the fiduciary responsibility of an employer for a 401k plan.
Right.
What's your take on that?
Well, as the baby boomers age and others, the pension accounts have become fundamentally important in our society. But there's a federal statute, which is known as ERISA, which regulates and requires certain duties of the trustees or the fiduciaries who manage these funds. So even if the employer is not giving any investment advice, and that's all handled by a third-party administrator, there are certain obligations that the trustee would have to make sure that that third-party administrator is competent and is giving a sufficient range of investments and investment advice to the employees. So they can't come back and say to the employer, look, you were negligent or you were faulty in carrying out your fiduciary duty. And a fiduciary duty is like a trust duty. So you're a trustee to a certain extent, although it's limited by federal law. So that's important. And you also need to get out certain disclosure documents so that the nature of the plan, the participation by employees, and what their requirements are well known to the employees when they first start out. And the major disclosure document is called a summary plan description, which would identify who the plan administrator is, certain rights under ERISA if you feel administratively you haven't gotten the relief you want to go to federal court, because ERISA creates rights under federal court law.
So where do you come in? Because we have Jim Musgrave with Research Financial Strategies, and he manages the 401ks, and you are an attorney, and you work with the HR department. You guys kind of work together on the same topic. Where do you come in, and where does he come in?
Well, the fiduciary or the plan sponsor, the employer, would come to me and say, look, Ted, we want to know what our obligations are to our employees. And we have a document that we've been given, which is called a summary plan description, but we'd like you to read it to make sure it covers all the bases, because we know that it's all set forth in federal law and regulation. So that would be an area where I would work with them. And if there's an amendment that's needed, I would draft that.
So do you work hand in hand with someone like Jim?
Yes.
Okay.
Absolutely. And if there's a potential claim, I could work with the plan sponsor or the plan administrator to see if that can be resolved. Certainly avoiding litigation if possible.
Okay, very good. Well, let's go into a little bit about you. You were admitted to the bar in 1985. Maryland and D.C., the U.S. Supreme Court and the U.S. Court of Appeals, the Fourth Circuit, U.S. District Court, District of Maryland, U.S. District Court for the District of Columbia. You also you have a biography of contributing editor to Employee Benefits Law Curriculum Supplement.
Yes. That's published by the American Bar Association.
And you're part of that.
Yes.
And you're also a member of the Cancer Board Chairman and also the Board of Trustees at Washington Adventist Hospital Foundation.
That's correct.
How did you get into that?
Well, and actually another investment advisor who I knew at the time, a number of years ago, who was on the foundation board, got me involved, and I found it to be an excellent cause, and we're in the process actually of working to support the construction of a new hospital at White Oak for Washington Adventist Hospital to expand dramatically the critical care services that the hospital currently offers and maintain its location in Tacoma Park for other purposes. And so it's very rewarding because health is fundamental. And again, baby boomers, as an aging population, we're all going to be confronted with health choices, and it's something I enjoy doing.
Wonderful. And you're also general counsel for a lot of large organizations around here. It's pretty amazing. It's like you do this for fun.
Well, it's interesting. It keeps my mind sharp, and I also get to meet a lot of interesting people.
Well, there you have it. Ted Stein, attorney principal for law offices of Theodore P. Stein, PC. Thank you so much for coming in.